Trey, you want to start us off, man?
Sure. Yeah. Well, I'd like to welcome everybody to what's, I think, a really interesting week. We're going to be talking about something that's been in the news literally everywhere. But one thing that's I think kind of exciting about this is it's in the news, in the popular news, but nobody's talking about the role of agriculture and environmental policy in the RBG discussion. And so I am not a lawyer. I know nothing about law except for that they exist. And in my economist heart, I think there are too many laws. So we thought we would reach out to somebody who is actually like a leader and an expert in agricultural law. So Jennifer Zwagerman is our Drake University Agricultural Law Center the director, right?
Director.
Yeah, the director of the
man.
Law Center. I don't know. You guys are the lawyers. I don't know these things. But she's also an alumni from Michigan State University, which we didn't know that when we reached out. We reached out because she's just a famous agricultural lawyer. But she happens to have a pretty deep roots here in the state of Michigan. So I think she's excited to join us just in that role alone. But especially because it's a topic that is so important that I think you were already looking at it from what I understand. Yeah.
We were, absolutely. Yeah, no,
Well,
I am thrilled to be here.
Yeah, thanks for joining. So let's jump right in.
Cool.
Right.
So do you think you can introduce yourself a little bit better than I just completely botched?
Well, I can attempt. I feel like first I need to prove my Michigan State, credentials here. So I threw in a history of my recent years here. So, there's me in Sparty when I came back for a recruiting event. You have pictures of my much younger children, my Facebook profile with their Spartan helmets. And then one of my favorites from, I guess it was 2 years ago now, when Michigan State played in the NCAA first rounds here in Des Moines, and my oldest son and I got to go sit. We were in the very top row. You could not get any higher in the stadium than we were. But as you can see, we were excited to be there. But no, my name is Jennifer Zwagerman, Jennifer Williams, when I was at Michigan State. And I'm originally from Deckerville, Michigan, so a little town up in the Thumb area where my parents still are. And didn't grow up on a farm, but anybody who knows Deckerville or the Thumb knows that that's the primary way up there, as you are absolutely embedded in agriculture and rural life, being up there. And so I came to Michigan State and sort of stumbled into agricultural communications. That engineering was my first instinct, and then after 2 weeks of calculus discovered that there was no way I wanted to do multiple years of that. But at the time, everybody I was hanging out with was from my hometown and in the College of Agriculture, and they introduced me to ag communications, and the rest was history. So I did that and graduated and worked in the Michigan beef industry there for a little while before coming out to Drake for law school, because Drake had the Agricultural Law Center that I now have the honor of directing. And so that was.
How long have you been at that center?
I've officially been the director. This is my second year, but I was associate director for a number of years before that. This is my 9th year at Drake. So I've been there a number of years. And so I am now I'm doing full-time academia in terms of a teaching load. And then we have the center as well. And so I compare it in a way that we are pseudo extension on the center side. We have the academic side where we work with students, I teach classes, but really the center is where we partner with a lot of organizations and institutions to try and do educational, put resources and guides out, policy. We put informational guides out both for producers and for lawyers, and just try and provide whatever types of information we have and really get students engaged in it to explore the areas of interest, whether you're looking into organics and urban agriculture, or whether you're conventional farming. We have students that are involved in all of it.
So, okay, this is me speaking out of having no idea anything about agricultural law. I know that almost every ag econ department I can think of has an ag lawyer on staff. But how does one end up in ag law? What is different from ag law versus regular law? What does your center, like specializing in agriculture, like there's a lot of pieces of agriculture. So like, I mean, are we talking about trade? Are we talking about like, what are the things that go into agricultural law more broadly?
That's a great question. And one of the best things about it is I put it sort of like my ag communications degree, frankly. I get, whether you're ag law or when I was ag communications, you get that broad, basic education. I can go out and be a communications professional, or I can go out and be a general practitioner and get my basic legal education, a very good one. Go Drake. But you just have the opportunity then to further explore the areas that interest you most. And so, for example, the classes I teach now include an introduction to agricultural law, where we talk about basically all the exemptions that agriculture has, whether it be labor or environmental laws and all of those types of areas. But we also cover sort of the current issues that, like Farm Bill and those farm programs and those types of things. A lot of ag credit, the bankruptcy, just we sort of hit the 10,000 foot level of those, and basically introduce folks to the unique aspects of that type of law. And then I also do things like a food in the law, where we talk not just about regulatory stuff like food safety and food labeling, but we really talk about food policy a lot too. In fact, this class this fall, we're really focusing on rural food access and rural food security and the policies that impact that, and what we can do to help coordinate efforts to increase that as rural areas lose grocery stores and access to fresh foods.
Okay, so you're teaching and you're doing extension. Do you do like research? Is that like
research is, yeah.
I don't even understand how ag or like law reviews work in general. So I
Cool, Trey.
I'm sorry, I don't know.
No,
so how does that work?
Yeah, I try and double up wherever I can. So being a one-person center with my student assistants that I pull in wherever I can means economies and efficiencies of scale, right? You know, we do what we can. So the research side is usually tied to the work we're doing at the center or something that I'm already going to be speaking on if I'm going to go do a presentation somewhere. The research I'm doing now is tied two different areas, one on data, kind of the data privacy within agricultural data that we're pulling up.
Yep.
And that was tied to a conference last spring, pre-COVID, so we could actually travel. And then I'm also working on like agroecological labeling and effectiveness of that, and other kind of opportunities if we wanted to try and actually drive change. What would be potentially a more effective type of labeling that actually has some teeth behind it or meaning behind it versus, you know, somebody slapping "I'm sustainable" on a label. So those are kind of the two things. And I can work that into my classes, which helps. And I can work that into different, like I said, presentations and things. But we do the research. We're grant funded. So we're constantly looking for where there's a need. And so our research often ties around where is there a need for either producers or lawyers to have some more information. And then how can we fill that?
Well, both of those things sound, well, that's right. But both of those topics sound like, I mean, extremely pressing topics. I feel like we need to have you on like 2 more times now to talk about both of those things.
I would be more than happy to do that. I'll be your outside legal expert from out of state.
There you go. Perfect.
Yeah,
we can bore Trey with all of the legal talk. And,
I like it.
You know,
I mean, I had to at least like ask questions that I understood so that like we can go talk about the real things now. Just so everybody knows, before we started it, Alex and Jenny were like, "Oh, what do you know about constitutional law?" And they're like doing the lawyer thing where they're like throwing out side jokes about the 12th Amendment or whatever. And I just kind of have to sit back and drink. In my mind, that's how it went. So, well, let's jump into RBG. Let's talk about at least a little bit about her more broadly, and then maybe we can kind of jump into the specifics.
Absolutely. One of my favorite people to talk about.
Why?
Such insightful questions from Trey. What is lawyer, and then why RBG?
No, I've always found her, even before I've sort of hit my current position, just extremely inspiring. Anytime you had those questions, like if there's somebody you could go have lunch with, or if you could have dinner with somebody who it would be, she's always been right at the top of my list. I think I love the feistiness that she always seemed to show, but just also the dedication and focus and compassion for equal rights, and her ability to disagree, as she said, and I think I have that quote in here later, disagree without being disagreeable. I think that she's just an amazing role model, not just for women in law, but for people in general, for how we can proceed in this crazy world of ours.
So it's not just the SNL sketches that make her look awesome.
I mean, how can you not enjoy a good Ginsburg? Because the Ginsburg, and that's impressive, but it's
We're only
not just
two
SNL.
minutes into this RBG conversation, and you managed to work that in.
I was looking for the right opportunity.
Yeah. So. Okay, so she, I mean, she's very well known for, I think, a lot of non-ag related topics.
Absolutely.
And if you followed the news at all in the last week, all of the non-ag related topics have come up. But I haven't seen a piece yet. Maybe I'm just not looking in the right places that have really, I think, effectively conveyed what her role, or even what more broadly the Supreme Court's role is in food and agriculture and environmental policy more broadly.
Absolutely. And I think really the focus for most of the cases that sort of she gets notoriety for, or even the court gets known for, tie more into environmental law. And the impacts on agriculture are often viewed as secondary, even when, we're going to talk a little bit about maybe some of the Clean Water Act cases or some of the water rights cases, that there's very little that's much more directly impacting agriculture than the ability to irrigate crops or to have access to water. And so most of the times when they talk about cases like that, it's environmentally focused, not agriculturally focused. And I think that does often get overlooked, let alone the contributions that they've had that have really helped focus on the ability for women in agriculture to sort of be able to come into their own and be independent farm operators, and the history that ties in there. I think women in agriculture really owe her a debt of gratitude in that area as well. And that's something that I think has really started to come out this week, was her ability and impact in some of those areas too. And I guess I should add, you may know her as Justice Ginsburg, or the notorious RBG. And I have to say, so I got a tour of the Supreme Court, I guess it was almost a year ago, last November. Our group got a tour, and the door to her chambers was open, to like her clerk's chambers. And they had this poster hanging in her office, or in her chambers at the Supreme Court. And I thought that was one of the most fabulous things, that in her actual chambers of the Supreme Court had the notorious RBG poster. And that just made my day.
I think that's one thing that's unique about her legacy, is that she got to enjoy some of that, right? A lot of this notorious RBG, Kate McKinnon sketch, the documentary, all of that came out during her lifetime. So she got to see kind of the change that she was realizing.
And it's funny that she would really sort of embrace that, because her personality, was the much more reserved, quiet. When you read all the stories and the biographies and talk to people, it was her husband that was sort of the outgoing, gregarious people person, and she was just sort of much more reserved and quiet, and not looking for the spotlight as much. And yet, in her more recent years here, really did turn and embrace that, which I think says a lot too about people's ability to adapt and enjoy kind of the moment as well.
I agree. So let's do it. So, and so before we do it, though, I want to disagree with Trey in that he said a lot of the stuff she did was non-agricultural related. And I think that is a really narrow lens to Trey. I think that's a really narrow lens to look through some of these impacts, and that they may not have been
mainstream media. They don't. That's
Yeah.
nobody's talking about the ag part.
Fake news.
And I don't know anything about the ag part, to be honest. Like I know some of the other stuff, but
what I mean is that other stuff has massive implications, which affect agriculture as well. So it's important to understand how those things have affected agriculture. And with that, I'll turn it to someone smarter than me.
Oh, I don't know about that. But no, I think you raise a good point, and things that I haven't even focused on here, but issues like antitrust cases that the courts have handled over the years. I mean, obviously there've been a few big ones that frankly I didn't think of till just now, or I should have looked up her position on them. But all of the trade secrets and Plant Protection Act and all of the intellectual property stuff with seeds in the last 30 years. I mean, all of those were significantly and directly impacting agriculture. But when you get into some of those broader issues that just have universal impact, antitrust comes to mind because we've had a number of those, obviously, issues raised in the last few years, and states' rights and interstate commerce and commerce clause issues and all of those types of things. It's not typically agricultural cases that we might reference when we're looking at Supreme Court precedent, but at the same time, they're having significant and daily impact on things that are occurring within our agricultural industry and food broadly ever since. So, well, you asked me what I was thinking about, and I sort of picked three key areas to think about and talk about. One, and I've sort of highlighted all of these, was her sort of pre-law, but also, or pre-court, but also a little bit on the court impact on focus, not just on women's rights, but really on gender equality, period. Everyone should be treated the same. Food, ag, and the environment, particularly that environmental side, some of the key court cases that she was part of, and then sort of a looking ahead. There are some big environmental and related cases coming up, maybe not even this year. There are a few this year, particularly water rights, but sort of in the pipeline, I would say, in the courts of appeals right now, that the next justice is going to be having a major impact pretty quickly on some key issues tied to environmental and agricultural issues. So with that, I thought I would do just some background quick. She was born, her first name was actually Joan, which is her daughter's name now, born in Brooklyn. Important to note, her mom was a major influence on her life. And this sort of focus on education that she had came with a big push from her mom, because her mom had to be sort of pulled out of school and start working when she was 15, even though she was apparently a very, very bright young woman, because her parents felt it was more important that her brother go to college as a male. And sort of that story impacted then Justice Ginsburg to really have the focus on education and doing something with the brain she'd been given. She graduated first in her class from Cornell, but unfortunately her mom actually passed away the day before her high school graduation, so never got to sort of realize any of this. But Cornell was where she met her husband Marty, who also became a very, very well-known, one of the top tax attorneys in the country. But she said that her husband was the first person to see her as somebody with a brain, not just as a female or as a woman to be interested in. After they got married and he started law school at Harvard, she followed him. He got drafted, and this was sort of one of the first times that she was, I would say, notoriously discriminated against. For one of the key areas, when she followed him to Oklahoma, she was pregnant with their first child and went to get a job, got accepted into the civil service there, mentioned that she was 3 or 4 months pregnant, and they basically just demoted her, dropped her salary, dropped everything. Wow. Because of the pregnancy. Once she then went to law school, really supported her husband through it. He ended up with cancer when they were in law school, but yet she still managed to graduate at the top of her class, technically from Columbia. couldn't get a job, top of her class, could not get a job. And it was because she was female. Judges would actually say, federal and Supreme Court judges say, I don't want a female in my chambers, send me a man, when the professors would recommend her. And she finally had one professor who refused to send this judge anyone else unless he interviewed her. And that judge hired her. She worked for him in New York there for a couple of years, went to Rutgers Law School, was a professor there. Significant, really fought. She had to fight for pay discrimination issues that were happening there. She had to hide her second pregnancy so she wouldn't get fired during her time there. And if you think about it, this isn't that long ago. You know, you know, shortly before I was born. And it really hits me when I was reading about this because, you know, I started my job at Drake pregnant with my first son. And I keep thinking, you know, there was no hiding it at that point. I mean, I was like 7 months pregnant when I came onto the job, but the idea of not being offered an opportunity or being fired because I was going to be having a child, and the thought was I should be staying home, really sort of resonated. 1972 to 80, she was a professor at Columbia Law School. And again, not that long ago, and this in my position now as somebody on the tenure track, her time in that 8 years at Columbia, she became the first female tenured professor at Columbia. Again, and that just shocked me that it's not that long ago that they had their first tenured female professor. She was appointed to the Court of Appeals in 1980, the DC Circuit by President Carter, and then to the US Supreme Court by President Clinton in 93. He wasn't, or she wasn't necessarily his first choice, but once he met her, apparently was sold, absolutely sold. And I think she was confirmed something like 96-3. You want to talk about a bipartisan confirmation. Absolutely. But in looking up from this, I pulled up Scalia was the same way. He was something like 94-5 or something like that too. So part of it is just a much more congenial, I think, collaborative time in the Senate as well. So here's my first.
Let me ask a dumb question because I'm not a lawyer. I've heard people say that the Supreme Court has more power now than they did at the time that she was selected. Is that fake news, or like what is? Explain to me like the role of the Supreme Court, or how has the role of the Supreme Court changed at all over that same period of time? Because if the court has become more political, then of course it's going to be more partisan when people are trying to nominate judges.
There is some truth to the partisan side, I think, but I think if you look at the power dynamic, and Alex, correct me if you think I'm way off base here, but if you look at the power dynamics and how people have viewed the court versus other branches of government, there's definitely been ebb and flow over the years. I mean, you go back to like when the Supreme Court was first established and all of the initial cases where they had to sort of fight to get recognition and they were seen as too powerful, right? As who has the right to tell me what to do as the state or individuals. My gut kind of feeling is that the more partisan the legislative and executive branches are, the more controversial the Supreme Court comes, because they're seen as sort of not countering, but balancing. I mean, here, that's the part of this, right? To balance maybe some of the more partisan, less constitutional actions that either side may take because they have power. And the more partisan that the other branches are, people are less happy when the court on either side steps in and disagrees and either strikes something down or maybe upholds something that's less controversial. But I think that independence can be something that's either revered, depending on which side of an issue you're on, or hated because of that. But I think the independent judiciary is probably one of, granted I'm a lawyer, so I'm biased, right? But one of the most important aspects of our democracy is the independent judiciary and the ability to have what is seen as an impartial panel to step back and look at an issue and say, you being society or you as a legislative branch may think this is the right thing to do based on your personal beliefs, but we're going to try and take that aside, put that to the side and tell you based on the law what is allowed or not allowed. And I think that's extremely important.
So I guess we can move on soon, but I guess you talked about two things. One is the power of the court, which has ebbed and flowed over time, and the other is the independence of the court. In your opinion, so that's, I guess, the brunt of the discussion for the replacement of Ruth Bader Ginsburg. In your opinion, has that changed over time, or is there still a pretty strong independence there?
I would say that is something that has definitely ebbed and flowed over time too. Sometimes you get folks that are much more consistently, I would say, middle of the road. Others are seen as very partisan, one side or the other. And I think that's part of the fear with the court right now, is that the person in office who's appointing them is seen as very, very partisan, not looking to find agreement, not looking to build consensus or find somebody that would have a 96-3, approval through the Senate. Instead, they're looking for somebody that can be as much as they want them to be and still squeak through. Right. I mean, that's a different perspective from the person appointing them. So there is a difference then in terms of how they move forward. But I think if you look back over time, and even with the current court, not everybody votes the way you assume they're going to based on who they're appointed. And I think Chief Justice Roberts has done that a number of times this year in siding with what's seen as the more liberal justices or side of the court in certain instances. And so, I mean, there's independence there as much as you try and pinhole somebody into it. The goal is that whenever you take that oath of office, you set the politics aside.
So, but I guess there's a difference there in my mind between whether I view or I interpret the law through what is seen as a liberal interpretation of the law versus a conservative interpretation of a law, versus which I see as still something that can be independent, right? Yep. I have a Scalia interpretation of the law, very federalist interpretation of the law. That still is an independent or unbiased interpretation, as long as it's kind of my framework. The question I guess I've seen is the risk that judges will be in favor, regardless of what their interpretation of the law, judges will be in favor of one particular party or the other in a way that doesn't have to do with their interpretation of the law.
And I would agree that the party kind of favoring comes in, but I think what's even more important when we're talking about judges at this level is their strength of belief in the idea of stare decisis, right? Of what's come before. And yeah, I know. I was just going to say, I was
all in.
But, and that's basically a recognition that what's done is done, right? You respect the rulings of the court that have come before you, even whether you agree or disagree personally, whether you might have interpreted or ruled differently. You don't just overrule previous law for the sake of overruling it. You only do so because something changes, or facts are completely different, laws change, but something has to happen typically. But stare decisis is basically a respect for what's happened in the past, and that it's settled. It's settled at this point, and I don't get to just reopen the case or reopen this issue just because I disagreed or would have ruled differently if given the chance previously. And that's what, I mean, you'll see in this next round of confirmation hearings that that has recently come up over and over again, primarily with the idea of Roe v. Wade. I mean, that's where you see a lot of those issues come up. But it really is a much broader issue than that when you talk about things like, I mean, Trey was laughing about our conversation earlier, but when we were looking at things like criminal procedure and stop and frisk and immigration issues and all of these types of things that come up before the court that at various times they have ruled on in the past, and yet variations of that come up. Do you reopen it because you disagree, or do you rely upon that previous ruling to sort of set the baseline moving forward?
So, and we're treading on my limits of constitutional law understanding here. So I'm a little bit fearful that I'm going to say something extremely stupid. But I just wonder if, like you talk about Roe v. Wade and some other decisions that are kind of perceived as at risk of being overturned. And so I guess in my mind, the Senate confirmation process is looking for, are they willing to go with precedent and this idea of stare decisis? But I think that the ideas we're talking about now is exactly the opposite, that the confirmation hinges potentially on their willingness to overlook or cast aside previous decisions. Is that right, or am I just talking gibberish?
No, I don't think you're wrong. And it's often, I think when you look at, or if you were to watch whatever this next round of confirmation hearings, whenever it comes up, it's going to be less about what is actually said in those confirmation hearings by whoever the nomination or the nominee is, but everybody's attempts to read between the lines. Because of course you're going to say, well, yeah, I believe in stare decisis, but you know what I mean? Like how big an exception or exemption are they willing to look at that with, to be able to find a reason to open something up or to find a difference, to say, but this is different, so I don't have to rely on this. So it's not always that initial, well, you know, statement or answer. It's the reading between the lines and the other answers and how that references back that I think is what people are really going to focus on, trying to get behind into the intent of an answer through there.
And so I think in my interest and excitement to go there, I think we got a little bit ahead of ourselves. So I hope we can come back to this conversation later.
Okay, so let me try. There are a million things. Like usually, I think in a lot of people's minds, when you hear Supreme Court, your first thought is Roe v. Wade. Those two things, like, they go together almost immediately. And so I don't really want to talk too much about Roe v. Wade because there are a million places you can go find about Roe v. Wade. What I'm a lot more curious about are these other things that people don't really associate with the Supreme Court.
Yep. And so, let alone with Justice Ginsburg. So
yeah, and so let's talk through some of these things, particularly as it relates to her and ag.
Absolutely. So this is one of her many jobs that she had prior to entering the judiciary. Was she was the founder and one of the directors of the Women's Rights Project at the American Civil Liberties Union. She did this basically in the same time she was at Columbia Law School there. And in her time there, argued 6 cases before the Supreme Court, primarily focused, again, on gender equality. And I draw that distinction because that was one of the reasons I think she was really successful and had the, I think she won 5 out of the 6 cases, which is an insane number of cases to win percentage-wise before the Supreme Court. But she didn't just argue for women's rights. She really, she took cases where men were being discriminated against. And one example would be, a young father, his wife had been the primary earner in the family. She was a teacher, died in childbirth. And the Social Security laws at the time did not allow a widower to draw Social Security based upon wife's income. Only widows and children could draw upon the females or the spouse's Social Security. And that was because the mindset was that the man was the breadwinner and it didn't matter what, women's contributions financially were minimal, so they didn't, a widower wouldn't need to do that. So there were several cases like that focused on sort of that issue of gender equality and equal protection under the law. And up until her really tenure with the ACLU and her focus on these issues, the 14th Amendment, the equal rights, equal protection aspect of it had really been focused on racial issues. I mean, that was when it first was enacted and was right after the Civil War. But she was one of the first to really successfully argue for equality under the law and focus on sort of the implicit bias and issues that the negative, I would say, issues that come up if you stereotype someone just based on gender. And so up until the work that she did with the ACLU, women couldn't serve on juries. You were seen as too important to the home to have a role in juries. I talked about Social Security, but I think one thing that's often overlooked, and this is where I think agriculture really started to benefit on the female owner and operator side, is that up until 1974, the work that Justice Ginsburg did paved the way for the Equal Credit Opportunity Act, which was for the first time allowed women to independently get a loan, get a mortgage, get a credit card without having their husband sign off on it.
That's
without having to
insane.
change your name. You couldn't get a bank account in your own name. And if you got married, you had to sign it over and change the name. That was just the standard at that time. And if you think now about, let alone a married couple who may operate a farm, but the number of independent women operators we have. And when we think about farm transitions and business planning and estate planning, the opportunities that this opened up for women to be a part of that transition planning process as an independent, full kind of partner in a business, I think really is something that is not as recognized as it should be for her contribution to the ability for women, not just in agriculture, but business in general, to really step up and take on the roles that they have over time through there.
I said that I was going to pull some data on that, and then I didn't. But maybe next week, Trey and I can pull some data on the share of operators that are women, and maybe how that trends over time.
I'm trying to remember. I actually used the NAS data sheet in my class this week. And if I had been smart, I would have pulled it up and maybe copied and pasted into my notes here. But it was something, I want to say 60% of farms, I could be completely off, correct me when I'm wrong next week and you find the actual numbers, but something like 60% of farms had some sort of a female operator in it. But the majority of those also had a male operator. They weren't an independent female operator, but you had some sort of female decision maker in over 50% of operations. And I know that is a number that has continued to rise even as operations number of operations tend to dip, but the role and decision-making role of women has definitely increased, particularly since the 70s. Let's see, when we go into the court now, and kind of the impact, and I stick with sort of the equal protection to start with here. And I use her quote here of when there are 9, because she's famously known for asking, or answering the question of, well, when will there be enough women on the court? And her response was, when there are 9, because there have been 9 men on the court before and no one batted an eye. So why would it matter if, we had 9 women? So how many is enough? Why not 9? But 3 kind of key cases, again, focused on that equal rights, equal protection clause that she was able to be a part of as a justice once she entered the court was some pretty big ones, I guess, in terms of impact. The first one was US v. Virginia. And I think of this, you guys, we've all been part of state institutions and state universities here up until 1996. And this was with the Virginia Military Institute. Up until 1996, state institutions were allowed to ban women, exclude women or students based on gender. And this was sort of the first time where the court specifically said, if you are, a state institution, you are not allowed to discriminate based on gender. And that these sort of antiquated expectations about what women can do are just no longer relevant. That if a woman can prove that she can, you don't have to lower your standards at the Military Institute. There's good reasons to have those sort of physical and various standards that you have, but you can't assume that women can't meet them. And if they can prove that they can, you have to let them through there as a state institution. And those sort of continue too. Ledbetter was an extremely big dissent that she was part of. And this was a woman who had been working at Goodyear. It was an equal pay decision. And the court ultimately said that she was too late in filing And her argument was, well, I didn't know until, I mean, it was people's pay to be able to compare what I'm getting as a manager versus what other people are getting. It's not an easy thing to find out. And so I found out, but it was, according to the court, too late. And Ginsburg really wrote a sort of a scathing dissent about this and really pushed Congress to make a change. And the very first law that President Obama signed was the Lilly Ledbetter Fair Pay Act in 2009. So she really had an impact in trying to drive change in that way too. And that was something that she's known for too, are the use of her dissents, right? It wasn't just saying, I'm going to disagree, but sort of laying the path of why and how, maybe it isn't the role of the court here, like in Ledbetter, to change this, but I'm going to tell you what needs to be done and how it could be changed. And hey, Congress, why don't you go work on this? So she's known for having that kind of leading dissent in there. And then finally, this is another big one, again, very controversial, and will come up, I'm sure, in this next round of confirmation hearings. But that's Obergefell versus Hodges, and that was the ruling that allowed marriage for same-sex couples in all 50 states. But she really pointed out that the idea of marriage, which is what people were talking about, the institution itself being affected by this, that this image of marriage that people were talking about that they were trying to protect was antiquated again, and that had already been struck down, that this relationship of a subordinate woman, dominant male. The 1982 was when Louisiana's head and master rule was struck down. Are we saying that states...
That'd be the worst rule I've ever heard of.
Let alone...
How is that true? In the 80s?
I know, and that's what I'm like, I was alive at that point. That should not have been happening then, or at any point. But, her point was, if we want to, cling on what this institution of marriage once was, do we need to go back to that? Should we allow states to say, oh, I want to go back to my Louisiana head and master rule, but at what point do we allow these sort of state decisions to be what this institution could be based on that history that we've already decided is not appropriate? Again, another kind of her emphasis on some of these of just women belong in all the places where decisions are being made really had a lot to do with the argument that you have to have women involved in decisions that impact them because nobody else really understands what that means. So not just the idea of implicit bias, but even the long-term stereotypes that sort of just resonate and impact our daily activities. And you see this with race, you see it with gender, with sexuality, whatever sort of stereotypes we have, and all of those implicit or even non-implicit bias questions. Her point was, again, that equal protection, equality for all, was that you have to include everybody in those decision-making processes to be able to understand the actual impact decisions have on actual people, very pragmatic type perspective. And you can't exclude anyone and expect it to be fair and not have that type of bias or impact. So here's where you really wanted me to talk about, that I just went off on my tangent, other side that, but some of the key...
I think everything you just covered is super important to food and ag, just like anything else. I honestly, the headmaster thing, that's going to stick with me because that blows my mind that was like, A, it's one thing to have like a ridiculous law. B, it's another thing to be so ridiculous about it that you're going to name it something like that.
Master.
So
yeah. I actually wrote that down to look up later this week because I read that and I'm like, that can't be.
That's unreal.
Right. No, there's a lot of those that you come up with, and it also, I think as a woman who worked in agriculture for a couple of years before going to law school, I still remember being told things like, wear pantsuits, not skirt suits, because otherwise they judge you. I mean, sometimes you play that to your advantage. And I've done that when I was practicing law, and I could go in and do a deposition of someone that would view me, maybe more like a grandfatherly age, right? And they would assume I knew nothing about farming or agriculture or anything in general. And, you know, I could go into a deposition and just start asking questions and get them to teach me, you know, but you could kind of use that to your advantage sometime, right? You know, get them to just get talking. And it was, you know, that's not a bad thing. But at the same time, it is something that, as you know, our industry itself is still very male dominated, and a lot of that sort of glass ceiling aspect. And so when you hear things about fair pay and, you know, discrimination and how women, whether through pregnancy or evaluations, are treated, that really does still resonate in an industry that is still adjusting to different sort of stereotypes and changes in those over time as well.
We're in agricultural economics, so it's certainly true for us too.
Yeah.
It's true in economics, and it's true in agriculture, and it is doubly true in agricultural economics.
Yeah.
So yeah, but let's keep going. Let's talk about ag and environment.
So I pulled a couple of decisions here that really, again, they're on their face, they're environmental, but significant agricultural impacts here as well. Justice Ginsburg was known as somebody with a very strong stance on sort of being pro-environment in that sense, and environmental protection was something that she seemed to favor in many ways, and voted often in support of environmental interests. One big one here, the first one on this list, is Friends of the Earth versus Laidlaw Environmental Services. That was a 2000 case. This was the first time that the court allowed private citizens to have a right of action to enforce violations of various federal environmental laws. And that was a question, the term they use is standing, which means, do you have enough of an interest in here, or are you impacted directly by this law in a way that gives you the right to sue to enforce it? So that's kind of the standing issue that they were addressing here. And, you know, we've seen a number of these types of cases since then over the years. A lot of nonprofit groups that sue. We have the children's case out in Oregon, where children were filing the lawsuit based on climate change and future. And those are the same types of cases where you have a private citizen or a group that represents them saying, because this law is not being enforced, I'm negatively impacted by this. And as such, I'm going to file this lawsuit to force you to fix the problem, to enforce this statute. And this one involved water. A lot of these involve water, but this was Clean Water Act, essentially. Whether or not just the fact that the water was polluted would give them enough of an impact to be able to sue, to enforce. And here they said, if you are limited, if you're not able to go use the rivers and the streams, then yes, you are impacted. These are areas that are designated for recreation and for social use. And if they are not maintained in a way that allows for that safely, then you are negatively impacted enough to be able to try and enforce that law. And so the impacts of that, if we think about now since then, where that opens up the door for enforcement through private action is really significant, because it can be good and bad depending on how you look at it, of course, but it does sort of open it up where if you end up with an administration that maybe doesn't believe in enforcing that particular law, it's still on the books, right? It's still there. It's still good law. That there is now still an opportunity for an outside person to try and enforce it, even when the administration says, I didn't like that law. I haven't been able to repeal it, but I'm just not going to enforce it. That's not really going to happen in all instances now, as long as there is that sort of significant impact on that private citizen to be able to try and enforce it themselves.
As long as that independence and stare decisis stuff. Yeah. I just think that so much of this is called into question, but I'll let you continue.
No, I think it really is going to
no, I don't believe any of this, but just keep going and it'll be fine. Okay.
It'll be fine. No, well, and this was another big one as we think about agriculture and the environment and the issue of, they referred to it in this Massachusetts v. EPA case as global warming, but really what we're talking about is climate change. And basically the ruling here compelled the EPA to control air pollutants. The court really said, no, EPA, you have the right, the ability, and the need to do this. Whereas before, EPA had sort of been hesitant to take that. And you know, if you think over time, again, you have different administrations try and pass one rule, another one steps in, they may not like it, may not want to enforce it, all of this back and forth. This was the court saying, no, EPA, this is your job. I mean, this is one of the reasons you were created. And in a way, this really recognized that climate change, global warming is an issue that the government needs to regulate. Not saying exactly how they need to do it, but this is, you know, a recognized role that government should play is in addressing these types of issues. And this was sort of the case that opened up the door for the Paris Climate Accord, which the US, of course, has now pulled out of. But this sort of led to that creation of that Paris Climate Accord initially.
So you touched on a couple things that and you mentioned the word enforcement a few times.
Yep.
And so that's something that I wonder about a lot. So like I've got a paper out where we count the number of regulations it takes to get a beer, and it's like tens of thousands of regulations.
Yes.
And so like just because the regulation is on the book doesn't necessarily mean that the enforcement of that regulation is consistent across places and time even.
Yeah.
So your next slide, I think you've got the Clean Water Act up.
I do, and that's a great one.
And that's exactly, yeah. Can we talk about that for a while?
Absolutely. So here are two key cases. One a little bit older that Justice Ginsburg was part of the dissent in, and one from just this year where she was part of a 6-3 majority opinion. The first is one that is still a huge issue. I mean, you can't talk about the Clean Water Act, agriculture, and waters of the United States without the Rapinos case coming in to discussion. Maybe people don't say Rapinos, but they talk about the issues in Rapinos, I should say. And that really comes down to the question of what's included. What is a water of the United States? What, you know, do the farm ponds, do retention ponds, do wetlands that I want to drain, do creeks that run occasionally, you know, or 6 months a year, but not year round, count as navigable waters. I mean, these types of questions are really what it comes down to in the Rapinos case, which was a Michigan case, wetland case, and came up with a plurality opinion. And what that means is if you look at the numbers there's no majority. It's a 4-1-4 decision. And it came down to sort of two tests here that are still used today. Different courts have upheld different versions of these tests, and that's essentially what the Trump administration is litigating now, is their version of the outcome of this case. And that's the significant nexus test or the continuous surface water test. And that's essentially, again, deciding what is a regular, what type of water can be regulated and what cannot. And when you talk about viewing it differently, states enforce this because they're actually the primary sort of enforcer of most of these, or regulator in a lot of these areas. And every state is different in here. In fact, if you look at some of the ongoing litigation, it only involves like 23 or 27 of the states. It's not all 50 states signing on to the same piece of litigation because they view it differently. And the question is coming into Justice Scalia, who wrote the plurality opinion here, said that only relatively permanent, standing, or continuously flowing bodies of water should be regulated here. So that was his sort of continuous kind of argument here, that there had to be federal, or to have federal jurisdiction over these waters, it had to have some sort of relatively permanent flow, like a river, a lake, or a stream. And a wetland, which was the issue here, would only fall under that category if there was some sort of continuous surface water connection between it and that permanent water body through there. The significant nexus took it a little bit differently and probably a little bit broader, I would say. You know, it doesn't have to have that continuous surface water connection, but there has to be that significant relationship, you know, between the two. So still has to be some sort of connection or relationship between them, but it doesn't have to be continuous, meaning year round, depending on rainflow, you know, all of those things. But that was sort of the question about navigable waters really is one that you mentioned, state enforcement, not consistent from place to place. This is a great example of that right there, as well as a variety of any of these environmental laws, from clean air and clean water and everything in between too.
So your next slide is predicting the future. So I'll make one prediction that I think RBG and company has created job security for lawyers, because all of this stuff seems super complicated to me. And I feel like, like depending on your knowledge of the law, you can either understand some of this or not understand some of this. But other than this increase or decrease in confusion, what is job
security? I like job security. That's something I do appreciate as somebody that is training lawyers, let alone in these areas. I do appreciate a little bit of job security in here. It's not hard to predict the battles that we're going to have, not just in Senate confirmation hearings. I mean, that's going to be obvious. Right now, there are 2 senators who have said, I don't support moving forward based on what happened in 2016 and that scenario. 2 Republican senators, I should say, who have said that. Everyone else on the Republican side has said, I'm voting for the nominee. Now, there is yet no nominee, which is interesting. I mean, they could throw my name out there, and apparently they've all committed to voting for me already, which is great.
Fingers crossed.
Yeah, I could handle that. I like those lifetime appointments. But at the same time, you know, it's again, when we talk about the partisanship of it, that's clearly a partisan saying, I don't care who the nominee is, I'm going to support my party. Yeah. There's not that independent review and analysis of qualifications or anything along those lines. And that's, to me, that's a problem. Whichever side of the aisle you're on, you should be evaluating someone based on their qualifications, not just based on the nominating party.
So in terms of the qualifications, I know we've only got 1 minute left, but in terms of the qualifications, you've got here footnoted in your presentation a couple of people who are strong candidates. Can you quickly tell us kind of where they fall on this spectrum of liberal versus conservative and where they might land on some of these things?
Absolutely. Both of the nominees are women. Judge Amy Coney Barrett, I think she's 7th Circuit, and Judge Barbara Lagoa of the 11th Circuit. Right now, Lagoa has kind of gotten a lot more attention because she's Cuban American, she's from Florida, and I think from a political standpoint, she may help an election kind of process with her nomination. Neither have strong environmental backgrounds or experience. There's not much to really look at with either of them. Instead, what you're looking at in terms of concern would be things like stare decisis, Chevron deference, which is how much deference do we give to an agency decision? Do we say they're the expert and that it's reasonable and not arbitrary kind of in how they made that decision? Those are kind of 2 key areas that I would say are going to come up in those hearings that would tie in to ag and environment, but really not as much of a background in these types of areas to look at. And then, you know, but there are some big ones coming up. The Clean Power Plan repeal, lots going on with waters of the United States. 2 key cases in the court this year tied to original jurisdiction, like in the court, battles between states over water rights, Florida, New Mexico, Texas, all of these ongoing battles. And that's only going to increase as we deal with issues with climate and water availability as well.
Keep going, go for it.
Keep going, okay. This was my last point. This was my last point is, if we want to think about her legacy, as much as I might have disagreed with Justice Scalia on just about everything he may have written or said. Their relationship is shocking to me for how strong it was, and the differences that they had on just about everything, politically, ideologically, legally, but yet they were the best of friends. And that's really sort of been coming up this week with both of Scalia's sons talking about some of the highlights of that relationship. And, they didn't talk law, but they were able to, find things that they had in common and shared interest and focus on those. And they had the ability to disagree, which they did strongly. If you read opinions where maybe she'll write a dissent or and write the main opinion, they could disagree vehemently and still get along. And I've had the opportunity to hear both of them speak. Justice Scalia spoke at Drake when I was a student, and just this past January, Justice Ginsburg was was the keynote speaker for a conference I was at in DC. Both were some of the most engaging and just fantastic dynamic speakers I've had. And like I said, I had disagreed with Scalia on most everything, but at the same time, I'm listening to his presentation and you're just so drawn into what he's saying. You're like, yeah. And then I'm like, wait a minute. It's like, no.
Oh, his opinions are just so metaphor spicy. I agree.
Yes, but he was so engaging and just this dynamic speaker. And she was the same way. The memory and the personality, this was, I'm going to leave you with just one of my favorite quotes. Well, actually, this is my favorite quote because I'm an avid reader. And so I think education is power. But this is, when she says, I want to be remembered as someone who used whatever talent she had to do her work to the very best of her ability. You don't have to be the best, just do the best you can. And between her relationship with Justice Scalia and the example that sets and this kind of strive to be your best, not necessarily the best, is what makes her notorious RBG. So.
What a wonderful tie around. That's why we got to have lawyers on here so they can just tie it up like that.
Lawyer.
Yeah. You've been, no, as Ginsburg. Yeah. See, but for a lawyer, you've got to give me a timer or a light up in the corner because otherwise I'm going to go until I get the buzzer, until I get the light,
It was so eloquent though. There is no need to put a light on. Thank you so much for joining us, Jennifer.
Well, thank you so much for the invitation. This was great. I love anything I can do with my Spartans here. And I don't know, you can see my dog's bed in the back. She's got her Spartan blanket. That's her favorite. But no, this was just fun for me. And I really appreciate the opportunity to talk with you guys.
Well, when the world's a little less weird, maybe we'll have you come give a seminar in AFRI and we'll talk more about the future of policy and law.
But I want her back on here because I want the opportunity to argue a little bit more. This was just all me learning about stuff. I want to.
We can argue. Absolutely. We can have some fun with this. Trey can be the moderator. And,
there you go. What is law?
Why is law? That's where we'll be. So until then, thank you, Jenny. We really appreciate you joining us.
Thanks, guys. Have a great weekend.
Take care.
See ya. Bye.
Bye.